Okay. Good afternoon, everyone. Are you guys both here on the Oliver versus Cuellar case?
Yes, Your Honor.
Yes, Your Honor. Good afternoon.
Okay. And so we have representing the plaintiff in the case is Mr. Zaidi. Is that correct?
That's correct, Your Honor.
And then Mr. Meyer, are you representing the defendants?
That's correct, Your Honor.
And then Mr. Money, who do you represent?
Your Honor, if I may, Mr. Money is one of the witnesses that I would call today if the court needs to hear from them.
And then who's Mike?
That is Dr. Hill, Your Honor. That's another expert that we're prepared to present today if the court needs to hear from them.
Okay. All right, let's go on the record on cause number DC 1715831, Oliver versus Cuellar. Counsel, make your appearances.
Jib Zedley for the plaintiff, Wynn Oliver.
Your Honor, my name is Brett Myers. I'm here on behalf of the defendants.
Okay. So I've read the plaintiff's briefing. I didn't see a response by the defendant, but did you guys file a response?
Your Honor, we did file a response last Thursday evening, and I checked today and noticed that I did not get a confirmation back from the court that it had been processed, but I do have the submitted notification from eFile Texas.
Have you seen it, Mr. Zaidi?
I thought I came through on Friday, but I did see something come through on Friday, Your Honor.
Okay, let me see. I'm going to share a screen. You can tell me. I didn't see it, but let's see. Okay, so well, that reminds me, there was a request to exceed the page limit requirement in the standing order that the civil district judge has signed. I never enforced that order, so I kind of regret I signed it. So I will grant plaintiff the leave to submit evidence in support of her motion excess of 25 pages. So let me see if do you see the response here? I don't think I see it.
Your Honor, I don't, but I've got the emails pulled up on my computer with the filing submitted receipt. So I don't know if that helps any.
No, I mean, I'm not trying to, I just haven't read it because it wasn't here. So you're welcome. Well, let's just see if we need it. Let's go ahead and start. Mr. Zaidi, you can start.
Thank you, Your Honor. May I use the share screen?
Yeah, let me stop sharing. All right, go ahead.
Screen sharing is still disabled, Your Honor.
Oh, sorry. Go ahead.
So, Your Honor, we've got two motions to exclude here. One is what I'll term the med-cost contained doctors, and one is on the biomechanical expert. I'm going to start with the med-cost contained motion to exclude. If I can get my screen sharing going here. All right, Your Honor, so I'm sure the court is familiar with the Delaware-Robinson standards. I'm not going to go over each and every one of them, but the 6 factors that have been provided to us in assessing reliability are each what are at issue at this case, and what we're dealing with when we talk about Mr. Money, Dr. Patel, and Dr. Duvall. So first, let's introduce MedCost Contain and Mr. Money. Mr. Money is the CEO of MedCost Contain, and among other services, they offer litigation support targeted towards defense firms. As you can see here from their website, they state that they provide e-file ready counter affidavits pursuant to Texas CPRC 18.001 to controvert plaintiff's affidavits. MedCost, through unidentified individuals, will prepare an audit of the usual and customary charges, write the controverting affidavit, and then send it to the physician to sign. I've highlighted the word here, charges, Your Honor, because we're going to focus on that later in my argument. Here you can see that this is the deposition of Mr. Money saying that MedCost Contain prepares the controverting affidavits. They prepare the medical audit. The physicians themselves, the ones signing off on the contributing affidavits, are actually ignorant of who writes the audit, what qualifications they possess, or if the audit was done correctly. Here in the deposition of Dr. Patel, you can see that I'm asking about who it could have been. He says it could have been Lance or Greg Money or another person, Carl Tillery. But he does not know if any of them are qualified to opine on medical billing or medical coding. And later on, I ask him, does he have any way to verify the numbers that are provided to him? And he says, no, he's relying on MedCost Contain to provide that information correctly. MedCost Contain in their audit will use several different methodologies. They'll have Medicare reimbursement, Texas Workers' Comp, NCI, and the question was posed to the physicians, why are different reimbursement methodologies using for different CPT codes? The physicians don't know. They're relying on MedCost Contain to apply the right methodology on reimbursement.
Mr. Zadie, can you slow down for me, please?
Yes, thank you.
Thank you.
This is the deposition of Dr. Duvall. He was asked a similar question. Why is 120% workers' comp being used as the correct calculation? His answer, I don't know. I don't create those things. You'll have to speak to MedCost, I guess. Further, the physicians don't do any independent research into the numbers themselves. Again, from Dr. Duvall, this is data that's provided to you by MedCost Contain. Absolutely yes. And you don't do any independent research to come up with these numbers. No. Regardless, the physicians sign off on the controverting affidavits that MedCost prepares. After review, and if there are changes necessary that in the language, they ultimately sign off. In this case, Dr. Patel and Dr. Duvall did not change any of the items provided by MedCost Contain. Each and every line item matched exactly what was provided by MedCost Contain. So let's talk about the data that's being provided. We know that Mr. Money, one of the potential authors of the audit, is not qualified to opine on billing. His only experience in this area seems to be experience at his own companies, MedCost Contain being one, and Pixidus Group being another. When asked these questions, he admits readily that he has not had any formal training when it comes to medical billing. Let's get back to that word charge and why that's important in this case. The methodology used by MedCost Contain, created by Mr. Money, centers on his misuse of the term charge in the medical world. As we've heard from the Supreme Court, and as everyone involved readily admits, in the world of medicine, a two-tiered structure has evolved. We have tier one, the billed amount, and tier two, the reimbursed amount. When medical providers use the word charge, they're talking about the tier one amount, the billed amount. Mr. Money is not talking about the same thing. I showed him the definition of charge as used by the AAA, which we agreed talked about the billed amount. He agrees, yes. And he says his definition is referring to something different. Yes. Here is SOAR, one of the providers in this case. They're referring to billed charges when they talk about charges, which Mr. Money admits is different than his definition. Progressive rehab consultants. That's not how you use the word term charges? Correct. Again, his definition is different. Injury One of Dallas, his definition is different. Applied Pain Associates, his definition is different. Dallas Radiology, his definition is different. North Texas Pain Specialists, his definition is different. The other physicians in this case, the defense experts, use the term charges to mean what is billed. Here's Dr. Duvall. Here's Dr. Patel. The charge will be the amount that is billed without regard to any adjustments, contracted rates, sometimes called the list master or charge master rate. Yes. But Mr. Money uses a completely different definition. I asked him directly, the way we see the term charge used in all of these bills is different than the way that you're using the term charge in your controverting affidavit. Yes, I believe that is accurate. Now, why is this happening? Well, we get that answer later in his testimony. If he used the same definition of charge as the rest of the medical world, including the experts that work with MedCost Contain, he would say, I am certainly not qualified to give an opinion in that regard. This methodology, as it is used, creates an implicit bias. Due to the way that he redefines charge, his methodology will only ever state that a charge is too high, and they will never ever opine that a charge is too low, even when their data says differently. Here's the audit done by Mr. Money in this case. And you can see on this line item related to x-rays, the amount that they put as the usual, customary, and reasonable charge was 48, despite the fact that their Medicare audit said it should be 75. So even when the data is against him, because of the way he uses the term charge, he will never, ever opine in a way that is negative for a defendant or a defense firm. There are other Daubert-Robinson shortcomings.
Let me ask you this, which I think is kind of the fundamental issue, which is prior to In re Allstate, I would have struck this. I would have already struck this witness, but under In re Allstate, I think it kind of changes what we as trial judges are required to do. And so, how do you this case is very old. I don't want to. You get a plaintiff's verdict here. I don't want it to go up and then me not let an expert testify that maybe under In re Allstate should testify. So how do you let's use the In re Allstate analysis and how do you deal with that?
That's fantastic to bring up, Your Honor, because I do think that it's worth discussing In re Allstate, although I don't agree that it's applicable to this case. In re Allstate was talking about what qualifications and what notice is necessary for a controverting affidavit to survive a challenge under 18.001. By their own terms, the Supreme Court stated that they are not opining on whether these controverting affidavits would qualify under a Daubert-Robinson challenge. And that's what we're seeing. That's what we're bringing forward today. In fact, in re Allstate, they specifically said that reliability was not part of the analysis of 18.001. Here, when we're looking at Daubert-Robinson, we're talking entirely about reliability. So in re Allstate is important to recognize, but it's just not the proper guidance for this case. We're looking at the Daubert-Robinson's challenge, which the Supreme Court was not opining on in re Allstate. Other shortcomings of this approach, Your Honor, this methodology was created by MedCost Contain for their litigation support service and does not have a non-judicial use. There's been no peer review of MedCost methodology, and there's been no real-world testing. As Mr. Money opined, he does not know if any of these facilities would actually accept the payments that he's laid out. So for these reasons, Your Honor, we believe that the reliability standards have not been met by any of the physicians or Mr. Money that are coming from MedCost Contain. What's happening and what we're seeing is the physicians are a shield to hide who's actually giving the opinions. The actual experts that are drawing the data, making the conclusions, are not even disclosed to us. So I can't even cross-examine them. When I ask the physicians, why was this number used? The response is, go talk to MedCost. They can't answer those questions because they're not involved on that side. They're simply there as a shield so that they have someone qualified to sign off on the 1801 affidavits. But now when we're talking about Daubert-Robinson and when they're going to testify in court, they also have to live up to the reliability standards. And in this case, we've seen that fundamentally from the get-go, they're off on the wrong foot because they are not using charge in the same way that's being used by the entire.
Did I already strike the counter affidavit in this case or no?
I don't believe so, Your Honor.
Okay. So you're planning, because you guys are going to trial in August on this. So what are you guys, you have a doctor lined up and everything?
I do, Your Honor. I'm planning on presenting, proving up our medical bills and treatment with testimony.
All right, Mr. Myers.
So, Your Honor, the fundamental issue in this case is whether the amount that providers in the locale actually receive is some evidence to help the jury to determine what is reasonable. That's the fundamental question presented by this motion. Now, before In re Allstate, I would have been hesitant to even have Dr. Patel or Dr. Duval not testify, because before In re Allstate, there was a question whether Mr. Money could actually provide this type of testimony. After In re Allstate, I believe that Mr. Money can provide this type of testimony. Mr. Money is as qualified as the expert that was at issue in re Allstate, and I'm happy to prove that up and provide the court.
Well, he makes the distinction that this is that's a different standard. We don't use the Daubert standard, I guess, now under In re Allstate. for counter affidavits, but we still need to use them for trial.
Yes, Your Honor. So the question becomes, is Mr. Money qualified? That answer, I believe, within Real State is yes, he is. Is the testimony that he is going to present relevant? The answer to that question is yes. An issue in this case is reasonable past medical expenses. The third element, Your Honor, is reliability. And in order for Mr. Money to testify as to what his calculation is as to the reasonable amount of past medical expenses, he relies on different sources, of which he is prepared to testify today to provide you with the way he comes up with that number. And essentially, Your Honor, that number comes down to this, and that is what is the amount that providers actually accept for these services in Dallas, Texas. And Your Honor, his analysis is based on Fair Health, which is a nationwide database. His analysis is based on the Texas Department of Workers' Comp. His analysis is based on all these other sources. And I would point out, Your Honor, the Texas Department of Insurance has specifically recognized Fair Health as being a neutral, transparent source of what it costs, of what medical procedures cost. What Mr. Money is doing is he is evaluating that database just like the expert did in Ray Allstate. If that procedure, if evaluating the database and providing the numbers in the database, if that is not a reliable way to provide evidence of reasonable, customary, and usual medical expenses, then the Supreme Court would have told us that in Ray Allstate. The Supreme Court would have said this is not a valid measure of how you go about doing this. That's what Mr. Money did in this case. Now, he testified exactly as to how he went about calculating what the usual, customary, and reasonable charges were in this case for each of the CPT codes listed. Now, if the plaintiff's counsel or if the plaintiffs do not like that, there is ample grounds for them to cross-examine him at trial. His methodology is sound and reliable. It establishes what the 80th, the 95th, the 50th percentile of providers in Dallas County accept for the type of procedures that are outlined in the plaintiff's treatment. All right. So we know what they're accepting. The question becomes, is what they actually accept some evidence as to what is reasonable, customary, and usual? And it would have to be, Your Honor, it has to be. It helps the jury to evaluate what is usual, customary, and reasonable for the types of treatment that the plaintiff received. Otherwise, the plaintiff's providers could say whatever they want to say. And from the defense perspective, we're left with no way to counter that. So that's where we are, Your Honor. And for that reason, we believe it absolutely is reliable. And Mr. Money can testify as to how he does it, why he does it the way he does it, and the results that he gets. If there's no guesswork, there's no guesswork here. They're not saying it's guesswork as far as Mr. Money goes. There's no speculation. What they're saying is they don't like Fair Health, the database that he relied on. That's what they're saying. And what I'm arguing to the court is that the Supreme Court has approved this exact same methodology as it applied in the Ray Allstate case. Now, and I will be candid with the court. Reliability was not the issue in Ray Allstate. But if the Supreme Court had an issue with using that database that was at issue in Ray Allstate, then the Supreme Court would have been in a position at that point to say, this witness is not qualified simply to rely on this database. So from that perspective, Your Honor, I'm prepared to put Mr. Money on the stand to go through his qualifications.
So let me ask this. So this is a motion to strike Greg Money, Wesley Duvall, and Vishal Patel.
Yes, Your
Is
Honor.
that right?
Yes.
Yes, Your Honor.
So we've just been talking about Mr. Money. We don't have a whole lot of time
Yes.
for this. So what about the other two? Are you still pursuing that, Mr. Zaidi, or?
Yes, Your Honor. So the reason that I focus so much on Mr. Money and the med cost methodology that he's created is because that is what's used by the physicians in this case. So they are using his data, and they then, which they then sign off on. And my argument is that the approach and the methodology that's used by MedCost Contain to generate that data is not reliable. It does not meet the Daubert-Robinson standards. And the physicians themselves cannot meet the Dahlberg-Robinson standards because they cannot explain why the data is what it is, why different reimbursement methodologies are used. Opposing counsel pointed out that Fair Health is among them, as is Texas Workers' Comp, as is Medicare, but there's no explanation on why it's Fair Health for some, Texas Workers' Comp for others, Medicare for even others, and none of the above for some beyond that. The physicians cannot speak to the methodology at all. It's all being done by MedCost Contain. And so that's why the focus was on Mr. Money and on MedCost, because that's the methodology that we're attacking, and that's what's being relied on by the physicians. They themselves cannot provide any background on the methodology as it relates to determining reasonable charges.
Do you agree with that, Mr. Myers?
I don't, Your Honor, because in their affidavits and in their deposition testimony, they testified that the charges were reasonable based on their own experience. They reviewed the charges, they looked at the charges, and as far as Dr. Patel goes, he said yes, providers would accept these amounts in Dallas County. So I don't believe it's simply and solely limited to the MedCost data. They had their independent basis for deciding that the charges that are being put forward by the plaintiff are unreasonable, and they signed affidavits and testified in their depositions that the numbers that they are proposing are usual, customary, and reasonable. So their physicians, they made that determination on their own. If there's a basis to attack their opinions, that would go to the weight or to the credibility of those witnesses. It wouldn't go to the reliability of it. They're doctors and they're offering that testimony. So we get back to Mr. Money. Mr. Money provided the underlying data that they used to formulate what would be reasonable, customary, and usual. And so when he presents them with that data, they look at the numbers and they say yes or no. So if there is...
So it sounds like, Mr. Myers, and correct me if I'm wrong, is that they rely on their own experience for one part of their opinion, and then they rely on Mr. Money for the other part of for a separate opinion. Is that right or not?
I think it would be, Your Honor, it is hard to parse through which is which. I think they look at the numbers as doctors and they decide, yes, this is usual, customary, and reasonable. And they test and they sign the affidavits to that effect and will testify at trial to that effect. So in that regard, they as doctors, I'm not sure what other, based on their own personal experience, I don't know what other reliability that needs to be put forward to establish that the doctors are testifying and that their testimony would be reliable. It would almost be if you were to say that the plaintiff is correct, then no doctors could come in and contradict medical expenses. That's the issue, Your Honor.
If I may, Your Honor, that is absolutely not the argument on the plaintiff's side. And what Mr. Myers said right there was exactly apropos. It is hard to parse through what is MedCost Contain and what is the physician. And in these instances, it actually appears that it's 100% MedCost Contain. As I showed in my presentation, the physicians did not do any independent research into the numbers. They relied purely on MedCost Contain to provide the numbers and to provide them accurately. And they don't know whether MedCost Contain is doing it right.
You showed something on the screen really fast, but I couldn't read it.
Apologies, Your Honor. Let me put that back up. I was showing this page from Dr. Vishal Patel's deposition, where I asked him if he had any way to verify any of the numbers that were provided to you. And he said that he could verify the Medicare numbers, but in general, he was relying on MedCost Contain to have pulled the numbers appropriately. I also referenced this statement from Dr. Duvall. Oops. This data is provided to you by MedCost Contain. Absolutely, yes. And you don't do any independent research to come up with these numbers. No. And in this instance, Your Honor, there are no other opinions. We're only talking about the numbers on what a reasonable charge should be. And when a MedCost Contain expert says this is not a reasonable charge, we have to ask the question, what do you mean by charge? Because they don't use that in the same sense as the rest of the medical world.
We don't have a whole lot of time left on this. Mr. Zaidi, I guess my question to you is, let's say hypothetically I strike Mr. Money as an expert, and then, but not the doctors. What I guess what I'm saying is, what I'm inclined to do is strike Mr. Money as an expert. Although I'm a little concerned after in re Allstate that could be reversible error. I don't know. But then allow the doctor. I agree with Mr. Myers that I don't know how I strike these doctors from testifying. Now, I may limit their testimony based on their own experience as opposed to using some outside database. But I don't see how, even prior to in re Allstate, I could not strike the doctors because, I mean, I've never said a doctor can't testify about charges in their field. I mean, that's plaintiff's doctors can do that, and so can the defense doctors. Now, what exactly I agree with you. The opinion should be what is a reasonable charge, not what is acceptable. If somebody accepts Medicare or Medicaid, they're going to accept a lower rate, but it's more guaranteed than this. But what they would charge somebody who's a self-payer, I think that is fair.
And if I may, Your Honor, the testimony that's being offered by the physicians is not what would be charged or billed to a self-payer. It is the same opinion, which is what would be reimbursed. Everyone from MedCost Contain is offering that same opinion. That's the data they're relying on. That's the opinion that they're offering. As Mr. Myers just pointed out, they're relying on Fair Health. Fair Health provides reimbursement data.
He said that they were relying on them in part, but they were also relying on their own experience. Or did I misunderstand that, Mr. Myers?
That's what's in their affidavits, Your Honor, and that's what's in their deposition testimony, that these are fair, these are reasonable, customary, and usual charges.
Yes, Your Honor. And when we ask them about the specific numbers that they opined, it is not from their experience. And I can put up one of their reports to show you. But it is either a Texas Medicaid Medicare number. It is, Texas Workers' Comp number. It is either a Medicaid Medicare number. It is either a NCI number. None of them are numbers that they say we came to this number based on our own experience. They're numbers that are provided to them by MedCost Contain and match exactly what they put in their report. No independent research is done. No independent verification is done. No checking is done to see if the audit was done correctly. No checking is done to see if it was done by the correct person. And then no checking is done to see if they were even talking about the same tier 1 numbers, which all of these resources that they're citing to, Medicare, Texas Workers' Comp, Medicaid, these are all tier 2 resources. These are all resources that are going to give you reimbursed amounts. And I don't argue that there is some relationship between reimbursed amounts and billed amounts. But if they're going to offer testimony about billed amounts, they need to offer testimony about billed amounts. And they haven't offered anything on billed amounts. None of their testimony relates to that.
Is that true, Mr. Myers?
Your Honor, yeah, I would agree with that. But I would also emphasize, Your Honor, as Mr. Zaidi just pointed out, the amount they actually receive is relevant to determining what is reasonable, customary, and usual for Dallas County. It has to be. And we're not talking about just one provider needing money. We're talking about billions of different medical treatments in the amount of money that medical providers receive for those treatments. That has to be some evidence of the reasonable, customary, and usual past medical expenses in Dallas County. What they actually put in their pockets, Your Honor, that is relevant. And it is some evidence of what would be usual, customary, and reasonable. If there's problems with the methodology, the plaintiffs can point it out at trial. If there's problems with the way that amount has been determined, they can impeach the witnesses at trial. But as far as the methodology itself, it is reasonable. And Mr. Money can testify to that. He can give you his background and he can tell you about that.
If I may, Your Honor, there's no one bridging that gap from tier 2, what they're opining on, what I agree that they're talking about, and what I agree has some relevance to tier 1. But there's no one bridging that gap on how we get from what is the some relevance to the tier 1 charges. That's not being offered by any of these experts. And that's what the jury is going to be asked to determine. What is a reasonable charge for these services? And no one is connecting the data and the information that's being provided by these experts to the question that the jury is going to be asked. And so even if we take the methodology aside, there's an analytical gap between what the opinion that's being offered and the question that the jury is going to have to answer. And there's no one here connecting that.
Your Honor, I would just go back to say what I've said now a couple of times, which is the amount that the providers actually receive for the specific medical treatments involved is definitely some evidence as to what is usual, customary, and reasonable for the locality.
I really am trying here, Mr. And we're in a kind of a weird area or weird period of the law in this, because before In re Allstate, I would have definitely struck Mr. Money, wouldn't have even given a second thought. I've struck about numerous of his counter affidavits. No offense, Mr. Money. And then the doctors, I usually look at, what I've always looked at in the past is if they're comparing to what is charged by other doctors to self-payers, doing apples to apples comparison. I've definitely allowed, not struck counter affidavits in that situation. I know this is a different standard, but also I'm trying to think, I've allowed them to testify. It hasn't come up a lot over the last 15 years, but I've had a couple of cases where you had a doctor testify and said, hey, the charge is unreasonable. And that's what I was trying to, so if it could fit within that methodology, I was hoping that, we could just strike Mr. Money and then allow the doctors to testify. We're in kind of a brave new world with In re Allstate. I don't know how, the Supreme Court, every time they've had a chance to kind of look at this, seems to agree with Mr. Myers, who, if the world was according to Judge Hoffman, that wouldn't be the law, because I think they're making apples to oranges comparisons. But if I get reversed, it's no good. I don't like to be reversed, but I'm not the one who's having to write all the briefing. And, let's say you get a significant verdict, it may just get overturned. What is it that you want here, Mr. Zadie? What is it that do you really feel that the Supreme Court would affirm me if I strike all three of these experts?
I can't speak for the Texas Supreme Court, but I really do feel that it will not depend on the ruling in re Allstate. And Your Honor, I think if that's really a concern for the court, that I would request that you allow us time to provide a supplemental brief on in re Allstate, so we can distinguish how the standards laid out in re Allstate for 18.001 affidavits are different than what we're dealing with here today, which is Texas Rule of Evidence 702 and Daubert-Robinson standards.
It's probably not a horrible idea, because I still haven't gotten Mr. Myers' brief. It hasn't come through. And so, but I will say this, is that this case is one of the oldest cases on my docket. We're starting up full, unless something changes with COVID, we're going to be doing jury trials back to normal on July 19th. I think you guys are set in August. And so this case is going to go to trial in all likelihood. And so I want you to kind of be aware of that in terms of timing on all of this, if that makes sense.
That does, Your Honor.
It does, Your Honor. And I only would say, Your Honor, that given the time frame we have ahead of us, it would be nice to be able to prepare the case for trial based on how the court's going to rule.
No, I agree with you.
And Your Honor, as we've been speaking here, I'm pulling up the in re Allstate opinion because I remembered this language from it. Because the qualifications were raised by the respondents in that case. And it says right here, Whether a witness is qualified to present expert testimony and whether the testimony is reliable are two distinct inquiries. And so I think by its own terms, then sorry, right here as well, it says, Alanes argued that the opinions in Dixon's counter affidavits were unreliable. They failed to give reasonable notice. This argument is flawed because determining whether a controverting affidavit meets the 1801 reasonable notice standard does not require a court to assess the reliability of the expert's opinions under Rule 702 or Robinson. That right there is the language that distinguishes in re Allstate from what's happening here today. They're dealing with section 18.001. We're dealing with Rule 702 and Robinson. The determination of whether Dickinson's opinions are reliable is distinct from the question of whether the controverting affidavit provides reasonable notice to Alanes. The trial court erred by importing a reliability requirement into the section 18.001 analysis. All language from the court that suggests that in re Allstate and Rule 702, Dobber-Robinson are not the same thing.
Your Honor, I do not disagree. In re Allstate it focuses primarily on the qualifications of the witness and answer the question that we had all been struggling with, at least from the defense side, have been struggling with. But I would go so far, Your Honor, to say that if the witness in re Allstate is qualified by reviewing the national database cited in the case in re Allstate, if that makes that witness qualified, then the review of that national database would also have to be reliable. So the question the court has to decide is whether Mr. Money, equally qualified as the person in re Allstate, reviewing a national database, right? Whether reviewing that national database and what he did to review that national database and come up with his numbers, is that process reliable? And he's here to tell you what he did and how he did it. Now, if the reimbursement amount or the amount the doctors actually receive for the medical services they provide, if that's not some evidence as to what usual, customary, and reasonable charges are, then I don't know what else would be there other than what the doctors say they should get. And so certainly no matter what the
I guess the way I've always seen it when I was in private practice, and I've always ruled, is that they do a review of what other, and this is what I've allowed in other cases, they do a review of what other doctors charge and in cases where there's self-payers, because this is a self-payer situation, right? It's not there's no health insurance or
That's correct.
Yes, Your Honor.
Medicare, Medicaid.
Same thing, Your Honor, that when we hire life care planners, they pick up the phone, they call providers around the area, and they request information about tier 1 charges. That's the approach that we take when we have to deal with this issue on our side.
Okay, let me talk to the next case. This was only scheduled for 30 minutes, so I don't know that I can get even to the other hearing, but Mr. Howie, are you here for the 2:30 hearing? Mr. Howie?
Oh, yes, Your Honor, I'm here. Yes, for 2:30.
Do you still need that time, or are you willing to waive your hearing?
Well, I was on because we got the notice that the hearing was still on. I thought based on the last hearing we had that the court was, that kind of maybe made the hearing unnecessary. But I mean, I have no problem waiting, just waiting till they finish up. That's no problem with me.
Well, the problem I have is that at 3, I have a hard stop at 3 o'clock because I'm doing I'm actually doing a charge conference on a case I'm in the middle of trial with right now. So I don't have, if you want to, if either side, is Mr. First your opposing counsel?
No, Judge, it was an agreed motion for continuance that we were here on, and the plaintiff's counsel with the court, I believe, granted his motion to withdraw at the last hearing. And I had my associate.
Wait, is your hearing at 3 o'clock or at 2:30?
2:30.
Okay, let me take a look at this real quick. are you here on the Pacina case?
No, Your Honor, the Phillips versus Sedona Village Wind River case.
Oh, that's not even set up. It's not set anymore. I don't,
Okay.
is anyone here on the Pacina case?
Your Honor, yes. Matthew Furs on behalf of the plaintiffs.
Okay. I apologize, sir. Mr. Howie, I don't see your case on the docket. Let me share a screen with you so you can kind of see what I'm talking about. I see we have a 2 o'clock case, which is these motions to exclude. And then at 2:30, we have Maribel Pacina versus Piedad Galvan. And then we have Ibarra versus Hancock. And that's not any of those of your cases, correct?
That's correct, Judge. And like I said, we had a hearing last week that I had thought had resolved the issue, but we got the notice, and so I assumed that I thought the hearing might still be on since we got the notice of the docket and the Zoom link. So
You may have just gotten that because you originally were. Yeah, don't worry about that. I apologize that that you had to wait through this, but no, you guys are excused. Mr. First, do you still need your hearing?
Your Honor, yes, but if it would assist my learned friends there, they're happy to, as my opponent's not here, I can give them another 10 minutes if that will help you wrap that up.
Your opponent's not going to be here.
Well, he's not here as of yet anyway, Your Honor, and he hasn't responded to correspondence, so I doubt I'll need the full 30.
Okay. All right, so we'll go ahead and go another 10 minutes on this Oliver case. All right, so I'm going to take up Mr. Zaidi on his suggestion that we allow you to do some additional briefing on In re Allstate. Let's talk briefly about this Michael Hill situation. So this is according to the plaintiff. And was there a response filed to this one, or is this also part of the response that
Yes, Your Honor. We filed it on Thursday, and I just checked, and it still has the submitted designation next to it.
Okay. All right, well, let's go forward. I've already read his motion, and I've dealt with this issue before. So let me, Mr. Myers, just kind of hear your response.
So, Your Honor, we get back to the same three issues. Number one, is Dr. Hill qualified? He has a PhD in biomechanical engineering. Are his opinions relevant? They are, Your Honor. They are relevant because one of the issues in this case is whether the injuries that the plaintiff is claiming in this case are consistent with the types of forces that she would have experienced in this accident. And then the third issue is he reliable? Is he reliable? And he is certainly prepared today to testify that he has gone through and used scientifically approved and peer-reviewed information to help him establish what those forces were. I will point out, Your Honor, that one of the articles attributed to Dr. Hill, he did not rely on that. The Nolan report, Your Honor, that was not something that Dr. Hill cited. And moreover, the Nolan report itself doesn't have the 80% error rate that the plaintiff is claiming. That's not what the Nolan report says. So from that perspective, Dr. Hill is here to testify today about his qualifications, if you want to hear about that, the substance of his opinions so that you can make a determination as to whether his opinions are relevant, and the scientific method that has been approved, has been used by other individuals who do the same work that he does. It has been subject to peer review. It has been tested, and it is repeatable. And there's no guesswork involved in what Dr. Hill does. What Dr. Hill does is he takes the photographs of the vehicles, and he also takes the depositions from the two people who were involved in the accident. And he takes the plaintiff's version and he uses his analysis based on the plaintiff's version and what he sees in the photographs, all of which is his way of determining ultimately what we call delta V in the vehicle dynamics. And then once he has the delta V in the vehicle dynamics, again, all based on scientific literature, once he has the delta V and he has the vehicle dynamics, he can then look at the types of forces that Miss Oliver was subject to in this type of accident based on her version of this accident. So there's no analytical gap there. He's basically saying,
So,
look,
so the main concern I have here, and I'd like to hear from both sides on this, is I'm not questioning his qualifications. Mr. Zaidi's probably too young to remember this, but probably Mr. Myers. Well, I don't know how long they've been practicing in this area, but I remember a number of years ago, there used to be these guys who would take a look at the pictures and then say, this is low impact and you're not going to, and you can't get injured in a low impact case. And I can tell by looking at the photos, you couldn't be injured. And there were a number of opinions that came out that said that's not reliable. It seems like that's kind of what's happening here, is he's looking at the photos and then deciding, okay, you can be injured or not injured.
it's not, Your Honor. I can distinguish it for you very, very easily.
Okay.
All the photographs provide Dr. Hill is evidence that shows him what was the angle that the vehicles were when they came in contact with one another. And he can look at the photographs and compare it to the literature, the scientific literature out there, and make the determination that this was a side swipe accident, which is completely consistent with the testimony from the two witnesses involved. Once we know it's a side swipe accident.
So it's not the severity of the impact, it's the angle of the impact, right?
He's talking about, he uses the photographs and the testimony to determine the angle of impact. That's correct. The angle of impact would then give him what we call delta. He finds delta V, which is the relative difference between the forces that impact on the two vehicles. Once he has the delta V, he can then offer, based on scientific literature, the forces that would have impacted Miss Oliver in this accident. He's not saying she wasn't hurt, right? That's not what his testimony is. His testimony merely is, this is the accident as it has been described to me by the people who were involved. Based on this accident, these are the types of physical forces they would have felt inside the vehicle. Then from there, he takes it one step further and says, looking at the injuries that the plaintiff is claiming in this case, do the mechanisms that result in those injuries exist in this accident? That's the sum total of what Dr. Hill is testifying about.
Response?
Yes, Your Honor, and I have to respond quite vehemently because that is, I think, very revisionist on the approach that was taken in this case, because the methodology that was used and how this progressed is that Dr. Hill looks at photos of the plaintiff's vehicle, no photos of the defendant's vehicle in this case, and then he compares that to an exemplar crash to determine how much force was imparted to equate to the same amount of crushing. And in this case, we're dealing with a 2008 Toyota Scion. He compared that to a 1984 Monte Carlo. Not the same car, not the same body type, not the same materials used. No measurements of the crushing, no measurements of how much damage was done, not even the same body panel that was impacted. He then takes his findings on the speed and then inputs them into what's called an HVE program. And what that does is it will model the crash depending on the parameters he puts in. So he's getting the speed from his photo analysis, which is completely subjective, and then he's inputting that into this HVE program. Now, in this instance, when he puts it into the HVE program, he still does not use the same vehicles. Instead of plaintiff's 2008 Toyota Scion, he uses a Toyota Yaris. Instead of defendant's GMC C7500, he uses a generic box truck, which doesn't have any of the matching equipment as defendant's vehicle had. And then now that he's modeled the crash using the speed that he had already gotten from his photo analysis, he then takes the forces calculated by the HVE program and uses that to say that the loads that plaintiff experienced were not significant enough to cause injury. And none of the studies, I shouldn't say none of the studies, a vast majority of studies do not stand for these same propositions. I'll show Your Honor exactly what I mean. So Your Honor, the exemplar vehicle I was talking about was a 1983 Monte Carlo. First off, when he does the HVE program, he agrees that it's a side swipe collision. He relies on the Pierce study. The Pierce study says you have to have tire rolling radius as one of your variables. He doesn't have tire rolling radius. So the study he's relying on says he's missing information. Additionally, the Pierce study says that if one of the cars is stationary, which was Miss Oliver's opinion, then that methodology is not reliable. It's only reliable when two cars are in motion. And he agrees with me. That's what the study says. When we talk about error rate, Mr. Myers says that this 80% error rate was not in the studies, Nolan study. That's absolutely not true. It says right here, for cars, about 80% of significant injuries in real world frontal offset crashes are occurring crashes with severity at or below those represented by the Institute's crash test. Here, the Comier study, which he cites as well, for saying that delta V is the right variable to be looking at, says delta V doesn't work in side swipes. Then we get into the Allen study, which he cites too. The Allen study says, looking at injury, you also have to look at musculoskeletal stress, social, cultural, psychological, and other factors, none of which are considered by Dr. Hill. He cites to the Fitano study. This is what he says that supports his opinion that there was no forward bending. But yet in the Fitano study, the driver's head moves forward and to the right, which is the mechanism of injury in this case. And then additionally, Your Honor, we've got new research in this area. We have 2021 International Journal of Environmental Research and Public Health looking at this exact same methodology. And it says, the biomechanical approach utilized by legal defense of injury claims in which the injury risk of a minimal damage rear impact crash is deemed comparable to the injury risk of activities of daily living is an invalid method for evaluating injury causation. This didn't come from litigation. This is a peer-reviewed literature looking at this exact approach and saying that it is not accepted, it is not valid. So the studies that he's citing are telling him he needs variables that he doesn't have. The exemplars that he's using are not from the same century as the cars involved. And the analytical leap he's making from this damage equates to mechanism of injury or no mechanism of injury is not supported by his studies. And the recent studies say that's not even the right approach to begin with. We didn't make any challenges to Mr. Hill's qualifications, so I'm not responding to that. We didn't believe that he was not qualified, but the methodology, the approach used in this case is just missing way too much. There's one assumption versus analytical gap after another. The way that he modeled the crash does not match either description by the plaintiff or the defendant.
Okay, so Mr. Myers, what we're going to do is we're going to reset this to Friday. So hopefully we'll get your brief by then, Mr. Zaidi, if you want to do some additional supplemental briefing on In re Allstate as to the original three folks. Unfortunately, we don't have time to do any live testimony today. And we'll see you guys. Let's reset this Friday at, how does 10 o'clock sound?
10 o'clock is fine, Your Honor. Just for clarification, are we going to be revisiting the Mr. Money, Dr. Patel, and Dr. Duvall issue, or just the Dr. Hill issue?
Both.
Okay.
Both. Okay. All right. Let me talk to the next case. We'll see you guys. And again, this will be, we said Friday at 10, correct?
Yes, Your Honor.
Yes, Your Honor.
Casey, can you go grab Rhonda? All right. Mr. First, are you ready?
I am, Your Honor. Can you hear me?
Oh, excuse me, Your Honor.
You are. Sorry. Thank you.
Thank you.
All right, Mr. First, you may proceed.
I'm grateful, Your Honor. So I have, logistically, I have a camera on and I also have another window open with a headset on. So hopefully this will work and I'll be able to share documents. Very briefly, Your Honor, as I appreciate we don't have much time. This is the plaintiff's motion to compel discovery responses.
Can you grab it for me? And this other hearing that's reset to Friday at 10 o'clock is Oliver Cake. I've already signed it. Friday at 10 o'clock. And guys, you'll need to move. Sheriff, if you can go ahead and let the attorneys in for the next hearing. All right, Mr. First, you may proceed.
I'm grateful, Your Honor. As I submitted, this is the plaintiff's motion to compel discovery responses from defendant Garcia. The three key deficiencies in the discovery responses she's already provided. First of all, she's not actually responded to our request for discovery under Rule 194.2. Secondly, although she's purported to provide late discovery responses, they're deficient in a number of respects in that she's failed to either state why she doesn't have the documents or has just failed to produce them. And then thirdly, finally, the responses are ambiguously verified. It's not clear from the final page of the responses whether she's verifying both documents, although Your Honor may well have a different view on that. The motion was filed on the 24th of May. Notice of hearing was set and sent to my opponent by email last Tuesday after the motion to continue was heard, Your Honor. And I've also sent the Zoom link by email. I've not heard anything back from Mr. Onyena, my opponent. And he's also, as you'll note from the brief, Your Honor, failed to respond to numerous items of other correspondence, both by post, by trying to serve through e-file, and also by serving him through the email address that he's previously provided on his pleadings. So with that in mind, Your Honor, I'd submit that we ought to proceed today
Go.
so that we can get on with the case.
All right, Mr. First, I'll go ahead and grant the motion to compel as requested. Anything else we need to chat about today?
I've submitted a form of proposed order, Your Honor. I have, as you'll note in the brief, at paragraphs 13 and 14, sought the expenses of this motion. Although I'm acting pro bono, I'm proposing that if we submit an affidavit and are awarded expenses, that they'll be donated to the Dallas Volunteer Attorney Program.
Okay. Sounds good. I'll go ahead and sign the order as requested. All right, thank you, Mr. First.
I'm grateful, Your Honor.
Mr. Clements, Mr. Robinson, are you here for the motion for continuance?
We are, Your Honor.
Yes, Judge.
Okay. You may proceed.
Yes, Judge. Thank you. This file, I just got it and entered an appearance on the 23rd. It was previously handled by Grant Dubois, and he recently left the office. And it was my understanding that him and Mr. Clements had worked out this continuance, and I think it was unopposed, if that's right, Mr. Clements.
That is
And,
correct, Your Honor.
I believe the depositions are done, the mediation is done, but I just got this file and it's set for trial, and so we're asking for a continuance.
Your Honor, if I may,
You may.
this case is one that we're probably ready for trial, but I don't think it's fair to defense counsel to just throw it at him at the last minute, expecting to jump in and understand all the nuances of what's transpired. And there's a chance we may be taking a doctor's depot if the court grants a continuance, so we could get that in the books and give Mr. Robinson time to catch up on the file. I'm sure it's not the only case he's got over there. And if he took over Mr. Dubois' files, I'm sure there's quite a few there that he's got to get up to speed on. And I would ask the court to grant the continuance to give Mr. Robinson time to catch up on the file.
Appreciate that.
Okay, how much time did you guys want?
It's up to Trey. I mean, I'll be right at the next setting. So
That's fine. I'll leave that to the court. 30 days, 60 days, something like that, I think will suffice. It was just a pretty quick turnaround from getting the file to Tuesday. So whatever the court's inclined to do, or if Mr. Clements has an opinion one way or the other, that's fine with me.
I just know my August is fairly open. September starts getting crowded up. But it's, if you need 60 days or more, I'd be glad to let you have 60 days. I mean, it's up to you.
There's a couple orders can go down. So, yeah, it should be 2. Yep, that's it. All right. Well, you guys just tell me what you want. I'll set it. We have a huge backlog of this case isn't that old, so the likelihood you're going to get reached in August and September are pretty low. But I'll set you whenever you like.
Just preferably not August 24th. I have a vacation letter for that weekend before that.
Okay.
So I think that's the only week in August that is on the vacation letter. And then October, I'm getting married, so October is not really good for me. But
We have a big trial, a 2-week trial in Houston in October, so that's not working for me. September works.
Sounds like September. And hey, Tony, can you come in here? We're about to start the charge conference. So let's do September. How about September 7th? Does that work?
Let me, if you give me just a second, I'll think I can pull my calendar without losing everybody.
you said the 7th, right, Judge?
7th.
Yeah.
But
that
I'm
looks
flexible.
good.
What?
How about that next week, Your Honor? Let's see, let me pull my calendar.
September the 14th. That works for me.
Mr. Clements?
2 seconds, Your Honor. I'm looking. June, July, August, September. You talk about the 7th? I'm out of town the 9th.
You wanted
10th.
the 14th.
I'm good on the 14th. Yeah, I'm good.
Okay, we'll go ahead and set you the 14th of September at 9 o'clock.
Thank you. Thank you. Thank you,
Your
Mr.
Honor.
Thank you
Clement.
guys. Good luck.
Thank you very much.
All right. Bye-bye.
Bye.
And then for those of you watching on YouTube, we have a live hearing here and a charge conference for the trial tomorrow that's also in person.